Today, BRR Media speaks with Doug Jones, who's the Head of International Arbitration at Clayton Utes, and David Rivkin, who's the Co-Chair of the International Dispute Resolution Group at Debevoise and Plimpton, and also the Secretary-General of the International Bar Association. Gentlemen, thank you so much for joining me today.
Thank you very much. It's a pleasure.
David, you're speaking at the 11th Annual International Arbitration Lecture, and your theme is that states and businesses have long depended on international arbitration to solve disputes, and that this has helped create the rule of law. Can you tell us how and why this has occurred?
Sure. Well, first of all, it's an honor to be asked to give this lecture. I'm grateful to be asked to do it. There is evidence of international arbitration being used as far back as the Greeks, and ever since then, international arbitration has provided some predictability and certainty for businesses and also for states. In ancient Greece, for example, there's even a reference to arbitration in the Iliad. In the Middle Ages, King Edward I in the early 15th century required that arbitration be available to foreign traders so that they could have a quick and effective means of dispute resolution in medieval England. States have also used arbitration to resolve disputes between them and solve and avoid wars. Again, going back to ancient Greece, there are treaties between city-states that submitted their disputes to arbitration. In more modern days, the trend was set by the Jay Treaty, which is the treaty between the US and Great Britain that solved the Revolutionary War. And that treaty set up arbitration commissions to deal with both disputes between the states over border disputes, and also disputes between Great Britain and American citizens who demanded certain claims. Both of those ended in effective dispute resolution and moved the relationships between the countries forward.
David, many states, including Australia, have complained that international arbitration under bilateral investment treaties improperly restricts on their sovereignty. Would you agree with this statement?
Well, all treaties, by definition, infringe on national sovereignty to some extent, because in any treaty, a nation agrees to undertake certain obligations towards the other one. Investment treaties are a bargain between states to promote investment in those states. And so part of the bargain is that the states give up a certain amount of that sovereignty in order to promote investment in their country and also to make it easier for their own citizens to invest in other countries. For example, investment treaties protect investors from being treated differently from nationals. We know that it's easier for governments to, for example, put greater taxes on or greater burdens on foreigners than on their own citizens, and investment treaties protect them in that way. So yes, to a certain extent it does restrict sovereignty, but it's usually in an effective way. And there is always a difference between a domestic law and what might be legal under domestic law and what would be legal under international law for that particular country.
And David, how can the system of arbitration under bilateral investment treaties be improved?
I think one key factor would be to increase the transparency and availability of third parties to participate in the process where national interests are at stake. The UNCITRAL working group has developed some very good rules that will increase transparency, that will make filings public, and that will allow proper interest groups to be able to participate and give their point of view to the tribunal. I think that will help tribunals balance the national needs with the particular rights of the investor under treaties. I also think that arbitrators in investment treaty disputes need to work on their timeliness. I understand that governments sometimes need longer to prepare in order to consult within the government, but still I think the time frames are too long, and certainly it's taken arbitrators too long to issue their awards once the hearings are complete. And I think in order for the treaty mechanism to work well, it's important that if there is a violation, that the consequences follow much more quickly, because otherwise it's easy for governments to take action and then to believe that other governments, the next government, is going to have to deal with the consequences.
Doug, international commercial arbitration has also been criticised lately for not reflecting the needs of business. Would you agree with this criticism?
To a degree I would. I think international commercial arbitration has tended to become over-lawyered, and as a consequence fails sometimes to deliver speedy economical resolution of disputes, which is what business people expect from arbitration, distinguishing it from domestic court processes.
Just finally, how can the process of international arbitration be improved?
Arbitration is a process that's infinitely flexible. It can and should be designed to meet the needs of each dispute, because every dispute is different in its character, and methods of dispute resolution can be designed to suit the particular dispute. Too often, unfortunately, we see the same process applied to disputes of varying character, and that is a great pity. I think that arbitrators and parties need to concentrate on what it is that's actually in dispute and do only what is necessary to solve that dispute in the arbitration process.
Well, David and Doug, some interesting insights. Thank you so much for joining me today.
Thank you.
Thank you very much.